Hey, my name is Nate Broady, lawyer turned YouTuber, and today I'm going to tell you why I have a fundamental disagreement with Robert Barnes, Alan Dershowitz, and my friend Viva Farai. But it's not only me who has a disagreement with them. It is the vast majority of academic legal scholars in the United States. Now, I got to start with giving you a little history. So, Alan Dershowitz has been making the argument that to impeach the President of the United States, there has to be an underlying crime. That's his argument. And to support this argument, he's citing another law school professor. His name is Nicholas Bowie.
Dershowitz has continually cited one scholar, Nicholas Bowie, an assistant professor of law at Harvard Law School, who he says supports his argument.
Professor Bowie, in his article in today's New York Times, equates abuse of power with, quote, misconduct in office. Misconduct in office. Thus supporting the view that when the framers rejected maladministration, they also rejected abuse of power as a criteria for impeachment.
Now, back in 1998, Alan Dershowitz was in line with most legal scholars of today who believe that, yes, you can impeach a president for almost anything, and it doesn't have to be a crime.
It certainly doesn't have to be a crime. If you have somebody who completely corrupts the office of president and who abuses trust and who poses great danger to our liberty, you don't need a technical crime.
But his understanding of the precedent has changed based on his reading of Professor Bowie. But Professor Bowie has come forward and said Alan has been misrepresenting his argument. So Alan Dershowitz has been citing Professor Bowie, and Professor Bowie has said, hold on, you are miscategorizing my arguments.
Professor Bowie, can you just explain your position on abuse of power and why you think Alan Dershowitz is misconstruing it?
Sure. So abuse of power is a crime. There are people around the country who have been convicted of it recently. It's a crime that's existed since this country was founded, and it's a criminal offense. To equate it with maladministration, as my colleague Professor Dershowitz does, is the equivalent of saying that criminal corruption is the same thing as getting a bad performance evaluation. Maladministration is just an 18th century term for doing a bad thing at your job, for not filing papers correctly. And I think he's right that a president shouldn't be impeached for getting a bad performance evaluation. But to equate that with criminal corruption, that's a joke. That's a joke.
And Professor Bowie then goes on to state on CNN that, yes, abuse of power is an impeachable offense. So even though the current argument by Alan Dershowitz, I think, can really be set aside because the citations that he supports have been destroyed. The person who wrote the paper that supports his argument, the only citation that he has brought up, says that he's wrong.
That's a joke.
And that his paper doesn't say that. So I'm assuming that it's going to be okay to dismiss this argument as an unfounded reference, because the reference he cites is incorrect. It doesn't say what he says it says.
That's a joke.
So now, there is more to Alan's argument than this loosely veiled citation. Alan does make an argument, but I believe Robert Barnes explains it extremely well. And if you want to see that, click this link up here, and it's going to take you to Viva Farai's channel. There you're going to see the interview that he has with Robert Barnes, who explains why they believe that impeachment has to have an underlying criminal act. Today, I'm going to show you the reasoning why the vast majority of constitutional scholars, I mean like 99.9% of constitutional scholars, and law professors, the people who teach this to new lawyers in schools, why the vast majority of those two groups believe, and I believe rightfully so, that you do not need a crime to impeach. All right, so first I have to start with our terms and helping you understand what the impeachment process is all about. So the impeachment process has two distinct steps. First, it has the accusatory step, where the House of Representatives formalizes an accusation against the president, saying you've done something wrong. And we generally call that impeachment. So if the president is impeached, that means he's been formally accused by the House of Representatives of committing some wrongdoing. And this happens with really any public officials. For instance, most impeachments have been of judges where the House of Representatives accuses a judge of some wrongdoing. And then we move to the Senate. Now, the Senate is the judge of impeachments. So when an impeachment comes to the Senate, they get to decide whether it is enough to remove the person from office or if it's not enough to remove the person from office. That's the conviction stage. So just to be clear, we have the accusation by the House and we have the trial in the Senate. Now, there are a lot of people who conflate both the accusational piece of the impeachment with the conviction piece of the impeachment. So I just want to make sure we understand that those are two separate processes. To help you understand why the vast majority of scholars and professors who teach constitutional law believe that a crime is not required for impeachment, I'm going to have to present it to you in two separate arguments. The first argument is going to be a look back at prior impeachments. Now, if impeachment is only limited to criminal activity or crimes, then there should be no reference of past impeachments of someone being impeached for something like, being drunk, for instance, or, something like crazy like that. Why? Because if impeachment is only about crimes, then I would suggest that all prior impeachments should be limited to crimes. And if we find those that are not, then that's a problem, right? Because the argument is impeachment is only for crimes. But also, if we find an impeachment and conviction for a non-crime, then that would also lead us to believe that impeachment is not limited to crimes. So my first exercise with you is going to look at the past history of impeachments and see if impeachments were only strictly limited to crimes. And the second thing we're going to look at is a Supreme Court decision where we have a unanimous, let me make sure I let you know this, a unanimous Supreme Court who tells us, who determines what high crimes and misdemeanors are. So on one end, we're going to look at the precedent, past cases of impeachment to see if they were only limited to crimes. And on the other hand, we're going to look at a Supreme Court decision from a unanimous Supreme Court explaining what the court's role is in the impeachment process. So let's start with precedent. Let's look at some of the impeachments of the past and see if impeachment was only limited to criminal activity. First, let's start with John Pickering, 1803. Now, the House voted to impeach John Pickering on March 2nd, 1803, and the charges were drunkenness and unlawful ruling. Now, the argument was made at that time in the House that these were not high crimes or misdemeanors. Now, the U.S. Senate convicted the judge and removed him from office, and he was convicted on all charges. That means he was convicted of being drunk. Now, the critics of the time said that while Pickering may have been unfit to serve as a federal judge, he had not committed any crimes. And they argued that he could not be removed from the federal bench. But he was. Our first example is a judge who was convicted for being drunk and removed from office. Now, Judge Mark DeLahey in 1873 was impeached by the U.S. House of Representatives. And what were his charges? That he was intoxicated on the bench. Yes, he was impeached for drunkenness. And the reason why it didn't go to a Senate trial is because he resigned. We now have two people in the past who have been impeached for drunkenness. Nobody's arguing drunkenness is a crime. Now, you're probably going to say, hey, Nate, hold on. Drunkenness, whatever. But what about what Trump is being charged with? Abuse of power. Has anybody ever been impeached for abuse of power? Which, again, Alan Dershowitz says is not a crime and not impeachable. There is a judge named George W. English, and he was impeached for, I think, 6 articles. But one of those articles was abuse of power. And he resigned before the Senate trial. Now, in 1831, Judge James Peck, he was impeached for abuse of power, but he was acquitted by the Senate. So it seems like we have a lot of good precedent here, even looking to past presidential impeachment, like the impeachment of President Andrew Johnson. The 10th article of impeachment against President Andrew Johnson was about bad-mouthing and disrespecting Congress. And oh yeah, in 1973, one of the articles that were being drafted up that weren't voted on was abuse of power. That was against Richard M. Nixon. We have a long history here of the United States of not only impeaching people for non-crimes, but removing them from office. Remember? So it is fascinating because it seems like the record shows of people not only being impeached of non-crimes, but also people have been impeached for the same thing that they're accusing Trump of now, abuse of power. This is why most of the academic scholarship in the United States believes that you don't need a crime to impeach a president. But that's only one part of the argument. Let's talk about part two. So I think it's clear that from the first impeachment and conviction of Judge Pickering, which was the first conviction for impeachment, he was impeached for being drunk. Even up to Richard Nixon, one of his articles was abuse of power. It seems that criminal activity wasn't a requirement and has never been a requirement to both impeach a public official, even a president, and convict them. But that was only the first part of my argument. The second part of this argument is going to be based on Supreme Court precedent. So this essentially comes down to one question. Who decides what high crimes and misdemeanors are? Who decides what is impeachable? Is it the court system? Is it the House of Representatives? Which branch of government has the ultimate authority to decide what is impeachable conduct? The U.S. Supreme Court answers that question in a case called Nixon versus the United States. Now, it's a 1993 case, and it's not President Nixon, but Judge Nixon. Let me explain to you what happened. Judge Nixon was impeached by the House of Representatives, and those impeachment articles were transmitted to the U.S. Senate. Now, the Senate didn't really want to have a full trial, so those articles of impeachment went to a committee. The committee recommended that Judge Nixon be impeached. Then the Senate had a vote on those particular articles of impeachment, whether they would convict Judge Nixon or whether they would acquit Judge Nixon. Judge Nixon was convicted and removed from the bench. Judge Nixon then went to the Supreme Court and said, hold up. I had a right to a trial. I was lawfully impeached, but I had a right to the trial. And I didn't have a trial. The senators just voted to convict me. I want my trial. And in a unanimous, and what I mean by unanimous, a unanimous Supreme Court decision, the Supreme Court of the United States said they could not review that case because the court has no role in the impeachment process. They could not review that process. So, since Judge Nixon got the requisite amount of votes to be removed, he had no case, and the court would not hear it. The court went on to explain why they can't review anything about the substance of any impeachment, including what are impeachable offenses. William Rehnquist writes for a unanimous court. A review of the Constitutional Convention's history and the contemporary commentary supports a reading of the constitutional language as deliberately placing the impeachment power in the legislature with no judicial involvement, even for the limited purpose of judicial review. So just so we're all clear, if the House of Representatives impeaches the president for jaywalking, for disrespecting Congress, and then the president goes and says, I want to challenge that impeachment because those are not high crimes, the Supreme Court will not review it. They will not take the case. It is the sole power of the House of Representatives to impeach. So our question now is answered. Which branch of government has the sole authority to interpret what is an impeachable offense? The Supreme Court? 9-0. It is the House of Representatives. And who has the sole right to judge those impeachments, whether those impeachments are valid or not? It is the U.S. Senate. So to the question of whether you need a crime to impeach a president, past history shows no. There have been people impeached and convicted for being drunks.
Individuals have been impeached, federal judges have been impeached for showing up to work drunk. Literally, the idea that now abuse of power is not the kind of thing that you can be impeached for is foolish.
The Supreme Court says that the House of Representatives has the sole authority to determine that question. What is an impeachable offense? And they can't even review it. So, hey, let me know how you feel. Do you think I'm wrong? Do you think the leading scholars in the field are wrong? Again, these are just two examples of why the vast majority of legal scholars in the United States and constitutional law professors believe that you do not have to have an underlying crime to impeach a president.